Taylor Swift just got sued for her album name Life of a Showgirl. I did a video on it and I received a lot of comments. As a trademark attorney, I'm going to talk about the arguments that both parties could make on either side. So first, you need to know that there are two separate things. There's the actual lawsuit itself, and then there is the trademark application. So they have two different systems, and I'll get into both. So first, let's talk about the trademark application itself. This is where Marin did things correctly. She filed an application back in 2014 and received her registration certificate for Confessions of a Showgirl. Then Taylor's application came in 2025, and at this point, her team already most likely knows about Confessions of a Showgirl because it's public information. It's something that is on the USPTO website when you go apply for the trademark, so you already see marks that could be confusingly similar. But Taylor's team went ahead and filed anyways. Maybe they thought, you know what, our mark may not sound that similar. Let's see what we can, why not? Let's just try and apply for it because this is the brand name for Taylor. And as you know from all of our videos, when we talk about trademarks, when you file for a trademark, it does not mean that you receive the trademark certificate. That is the easy part. That's the beginning where you just file. So the next step is that application gets assigned to a trademark examiner, and there are also attorneys who are on the other side, and they decide, does your application meet the requirements to actually get the registration certificate? So in this case, that trademark examiner that's assigned to this file saw this application and said, you know what, there's two other marks. One is a pending application and the other one is Marin's mark, Confessions of a Showgirl. And those two marks, the other mark, pending mark being Showgirl for fragrances, and then also we have Confessions of a Showgirl, which is filed and registered for entertainment services. Now you have those two marks that are blocking Taylor Swift's application for this brand name. So in order to get this trademark registered for Taylor Swift, she has to come back and find good arguments in order to overcome this refusal. So fast forward to now, Taylor Swift's application for Life of a Showgirl is suspended, and suspended sounds like it's a bad thing, but really it just means that it's on hold, because when you have a mark that's a pending mark, in this case, Showgirl for fragrances, because that mark is pending, and Taylor Swift's application also includes fragrances, so that's where the blockage is. Because it's pending, the trademark examiner says, okay, well, we're going to put your mark, Taylor Swift's mark, on hold, and we're going to wait to see, okay, what happens with that pending, because if that pending mark ends up being abandoned or doesn't get registered, well, that just opens the gates for her mark to move forward. Not completely though, because she also has to argue there's that second mark, which is Marin's mark. She has to also fight that one as well. So Taylor Swift's application is an uphill battle. It's an uphill battle because she has to find out what happens to that pending mark for Showgirl for fragrances. And then also we have that registered mark, which is already registered, and they have to make arguments for why their mark is not confusingly similar. So that is the trademark world, and that is the filing trademark system. Now, separately, we have the lawsuit, which is what we talked about in my last video. And this is where Marin claims trademark infringement. So now we're no longer in the world of, hey, is the USPTO going to accept the filing or not? She's saying, forget about that. Right, for right now, what I'm dealing with here is that consumers are getting confused. I have proof of this confusion. There's just a lot going on, and I feel like I should be compensated for this. In the lawsuit, Marin makes some really great arguments. Go back to my video where I talk about what she claims. If I was Taylor's attorney, I would really focus on the fact that these brands or these words are not confusingly similar. I would focus on the fact that confessions is very different than the life of or life. And I would really provide evidence backing that up to show that consumers would see these completely as different brands. Another point that I would make is that Marin is a live show, so her brand is for a live audience, and we know that for Taylor Swift, this is more of an album. This is different. It's not really the same, and consumers are smart enough to not get confused by the two. So I would also focus on that as Taylor's attorneys. I would argue that the word showgirl is actually very weak and that the other words in the brand name are stronger so that consumers are more likely to focus on the words confession and life of. And I think asking Taylor to completely rebrand is a really tall ask. So I do think that there will be a settlement in the end, but I will keep you updated on this so you can follow to see what happens with this case, because I myself am really curious to know what is going to end up happening.